anymore then.
Do I go position myself in there now?
Your Honor, would it be okay to send Mr. Turner into the witness room?
That sounds good.
Screen, start video, and leave yourself on mute.
Did you
until
just
they ask for it.
leave the same exhibit binders in there?
No, I brought mine in.
Oh, so do you want to just take those exhibit binders?
Lift with your legs.
Yes.
Yeah. There you go.
We're missing Attorney Marshall. Oh, there we are. No, he's not back yet.
I didn't see him.
Can I have your binder, D?
Huh?
You want to put your binder here?
Yes, but you can't move my stickies.
Evan, just.
Can I have that notepad? Just
Yes, you may. That's right. Take
Actually,
whichever
that's fine.
notepad
Yeah.
your little heart desires, my friend.
Don't touch my stickies.
I'm not gonna touch your stickies. You're being a little weird about the stickies. All right?
I'm very anal.
You're being a little weird about the stickies. Oh my gosh. Here, put your note, just put it up here. Oh my goodness. I know, but if these pages don't go over, then that's. Oh my goodness. The
So
dilemma.
it's all set up the way I like it.
You're getting real crotchety in your old age, man. Just.
COVID has given me no patience.
It was not COVID.
Okay. Are we all ready to go?
I was going to say, Judge, if you can just give me 1 second, I have to start the courtroom recording.
Super. And Mr. Turner, you're going to need to unmute yourself.
Yes, ma'am.
Okay.
Okay, we're all set on my end. Thank you.
Okay. Welcome back after break, everybody. Housekeeping matters first. Attorney Marshall, did you figure out potentially how to modify your schedule so we can go till 4:30 today if necessary?
Yes, I absolutely could do it. I just would have to make a phone call prior. I don't want to hold up the court. It's just if we ended up finishing it with a witness at 3:45, maybe it might make sense to wait.
Yeah, absolutely.
Thank you, though. I appreciate
Let's
consideration.
see how far it goes. Okay. So we're ready for the next witness, and that's Mr. Evan Turner, as I understand it, for plaintiffs.
It is, Your Honor.
And he is now over in this room by himself. So I'm going to ask the reporter to swear him in, please.
Would you raise your right hand, please? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay,
Thank
Ms.
you.
Crowley,
And so
you got a little laggy for us just now, Ms. Crowley. Are we lagging for you at all?
So I was telling the Your Honor on the beginning of this, I am hardwired in, so I might be laggy to you, but none of you are laggy to me.
Okay.
okay.
Sorry for the repetitive nature of that question.
No, that's okay. I feel bad, but it's fine on my end. I just wanted to give you guys a heads up that that's what's going on my side.
So Mr. Turner, just wanted to review with you that you've reviewed with your counsel, the order for video conference trials.
Yes, ma'am.
And you're in a room by yourself now, there's nobody else there.
Correct, Your Honor.
And you agree that you will not have private conversations, no texting, emails, hand signals, anything of that nature. You're just going to testify based on your own memory and knowledge of the situation.
Yes, Your Honor. I've just got the exhibit binders here and the controls for the video.
Okay, super. And again, just to remind you, it's all a little bit, we're all learning how to do this Zoom trial, but if you see one of the attorneys raise their hand, or if I do and ask you if there's a question currently before you, just pause and wait, and there may be an objection that I have to rule on before you would give your answer, okay?
Yes, ma'am.
Okay, super, let's get started.
Thank you, Your Honor. Okay, Mr. Turner, can you please state your full name for the record?
James Evan Turner,
And where do you live, Mr. Turner?
Boston, Massachusetts.
And did you go to college?
I did.
Where was that?
The University of North Carolina at Chapel Hill, and afterwards Penn State.
And which degree did you receive from UNC?
Political science.
And how about Penn State?
A master's in solar energy systems.
And where are you currently employed?
I work for myself under a sole proprietorship LLC,
And what is the name of that LLC?
Aries Power Systems LLC.
And what is the nature of Aries Power Systems business?
Consulting on solar energy development in Massachusetts.
How long have you been doing this work?
3 years with the LLC and 2 years prior to that with another development company.
And what is your relationship to AMP Solar?
They contract me to identify sites and bring them through the development process.
How long have you been working with AMP Solar in that capacity?
I've been with them as an outside consultant since 2017.
And how many of these types of projects have you done with AMP in Massachusetts?
More than a dozen.
And could you describe generally what your role is in the identification and permitting for these sites for AMP Solar?
Yes, ma'am. So my work will start with identifying a piece of property that can be gotten under contract. In this case, it's a purchase option agreement. Afterwards, I will work with AMP to put in a interconnection application to make sure the proposed facility can fit on the local electrical network, typically the wooden poles that run along the streets. Following that, I will work with the AMP team to craft an application for a site that is in conformance with local bylaws, as well as do the public meetings in support of that application.
And were you involved with the application to the Wilbraham Planning Board for a special permit to construct a large-scale ground-mounted solar energy system at 285 Three Rivers Road in Wilbraham, Massachusetts?
I was.
Who was the applicant on that permit?
ASD Three Rivers MA Solar LLC.
Can you please explain to us what the relationship is between AMP Solar and ASD Three Rivers MA Solar LLC?
Yes, ma'am. The LLC, ASD Three Rivers MA Solar LLC, is a project company that is created to hold all of the project-specific documents and transactions. So in this case, it is the entity that has the site control. It also holds the interconnection and would hold the permit. It effectively is a box for this project.
And you were hired by AMP to assist ASD Three Rivers with the application to the Wilbraham Planning Board?
Yes, ma'am.
Can you describe your role in the process for preparing this specific application and working to get the special permit?
Yes, ma'am. So relative to the application, it is part of my role to assist AMP and with their other contractor, in this case, TRC, to put together a comprehensive package reflecting the bylaws and other supporting information required to permit the project. That will start with a narrative. We'll go through several technical documents, such as the interconnection work or a noise study, etc. And then we'll also include the large engineered plan sets provided by TRC, who designs those in consultation with AMP, and really the entire team, which you have spoken with, myself, Mr. Cook, Mr. Rickard at that time, and Mr. Jeff Brain.
And what would be your next step in the process after compiling the application?
It is typically a courtesy meeting with a public board who will get this application to let them know it is arriving. At that point, during most application processes, I will have been in front of a conservation commission first in order to do any wetlands work. You want that set so that you have an application that is relatively firm going into the public hearing process with a planning board, because wetlands can and do dramatically change from what you initially expect. So since the application is typically socialized very early with another board in town, my first step is usually a courtesy meeting with a board to let them know an application is coming. And since they are somewhat voluminous and can be a long process.
And after that courtesy meeting that you've testified about and the application being filed, what would your next step in the process be?
Filing the application prepared by TRC and to the planning board for Wilbraham.
And then would you attend public hearings in front of the planning board?
Yes, ma'am. That is one of my roles, serving AMP as a client and ASD Three Rivers MA Solar in particular in this case.
You testified a minute ago that very often before even the first meeting with the planning board, an application has gone before a conservation commission, correct? I'm sorry, we didn't. Okay. Did such a conservation commission meeting happen with respect to the application that we're about here today?
It did.
And after that conservation commission meeting, did you then have the courtesy meeting with the planning board that you've described?
We did.
Approximately when did that first meeting with the planning board take place?
I don't remember exactly. I believe it was approximately 2 months prior to the initial application, earlier in the year.
So that would have been, say, June, July, or August of 2018?
Yes, ma'am, that sounds right.
And who attended that first meeting?
That would have been just myself.
And did members of the planning board attend as well?
Yes, they were there.
What was discussed at this initial meeting, Mr. Turner?
Introduction to myself and the project company that they obviously may have heard about through the Conservation Commission. Request for any additional information that the board finds relevant to an application that aren't perhaps immediately apparent, and general just notification that the application will arrive in the near future.
And in this meeting about this application, did the board offer any guidance with respect to your application?
They did not.
Did the board express any concerns about the application for 285 Three Rivers Road that you had described?
They did not.
Did they express any questions to you about the application?
They had no questions.
And during this initial meeting, Mr. Turner, did the board mention that there would be a building coverage or a lot coverage requirement that would apply to your application?
They did not.
Did the board mention at that time that there were any other large-scale ground-mounted solar energy systems operating or permitted in the town of Wilbraham?
I don't believe they did, although I think we were all aware that there were other systems historically in the town.
And did the board mention any other pending applications for large-scale ground-mounted solar energy systems in Wilbraham?
No.
How many times did ASD meet with the board before the application was filed in August of 2018?
Just that single time.
If you can turn to your exhibit binder, Mr. Turner, and turn specifically to Exhibit 1.
Yes, ma'am.
What is Exhibit 1, Mr. Turner?
Application for special use and site plan review for ASD Three Rivers MA Solar LLC.
And is this the application, the initial application that ASD Three Rivers filed in support of its special permit?
It is.
And is this the application that was filed after this courtesy meeting with the planning board that you've just described?
It is.
When was Exhibit 1 submitted to the town?
August of 2018, looks like received on the 27th.
Who prepared this application, Mr. Turner?
TRC.
Did you have a role in that preparation?
Yes, ma'am. I work with Jeff Branch, who works with AMP Energy and ASD Three Rivers MA Solar LLC to put together the application. I would be responsible, by example, for a large amount of the narrative, as well as the volume and material around some of these specific documents, such as, for instance, the interconnection section. I would write the narrative explaining what that was.
And can you describe generally the process that would happen when you would work with Mr. Brandt and TRC to compile this application?
Yes, ma'am. So you look at a site and you figure out all the things that are required to make a successful application. In this case, it's pretty much literally the table of contents. You would look at the bylaws to make sure you have all of the appropriate documentation required. That would primarily be a site plan, elevations, wetlands, the array layout, and all of the inclusive items on the engineered and stamped plan set. In addition, there are things that you have to put together, such as an operation and maintenance plan, a decommissioning plan. The pollinator mix, for instance, is one we like to provide you as an applicant, of course, can do extra and above and beyond material if you think it improves the quality and substance of your application. So I would work with TRC, who has a large roster of specialized and certified licensed people to do all sorts of things. For instance, they've got certified wetland scientists, certified ecologists, licensed and professional engineers to put together all the various items. We compile those into this application with all the supporting documentation, which is rather voluminous, plan sets and this stack of information, stormwater reports, etc. And those are put together by TRC and submitted on behalf of the applicant.
In addition to reviewing the bylaw, Mr. Turner, to determine which criteria would be applicable to the relevant site, would you also have discussions with the town?
Yes, that would, for instance, be the courtesy meeting.
Okay, I'll ask you to turn to Exhibit 2 in your exhibit binder, please. Okay, Mr. Turner, what is Exhibit 2?
The zoning bylaw from Wilbraham with a printing date of August 2018.
And is Exhibit 2 the zoning bylaw that was in effect and applied to the application that is marked as Exhibit 1?
Yes.
And is this the version of the bylaw that you would have turned to determine the requirements for Three Rivers application for a special permit?
Yes.
Okay, Mr. Turner, please turn now to Exhibit 3 in your exhibit binder, which I apologize, but this one's it's a hefty turn. Do you see Exhibit 3, Mr. Turner?
I do.
And what do you understand Exhibit 3 is?
The written decision of the planning board for the special permit application dated January 30th, 2019.
And is Exhibit 3 the decision denying the application, which has been marked as Exhibit 1?
It is.
I'm going to ask you to look at the first 2 pages of Exhibit 3. And on those first 2 pages, there is a list of documents filed. Do you see that?
I do.
Is that list a list of the materials that were submitted by ASD Three Rivers in support of its application throughout the application process?
Yes.
Was ASD Three Rivers required at any point during the application process to submit a building coverage or lot coverage calculation for the site?
It was not.
Did the board ever request that ASD Three Rivers perform a building coverage or lot coverage analysis pursuant to section 4.4 of the 4.4.4 of the bylaw?
They did not.
Can I ask you to turn to Exhibit 4 in your binder, Mr. Turner? What is Exhibit 4?
TRC providing 3 copies of the revised plans for the ASD Three Rivers Solar Project dated 13 September 2018.
And why were these large-scale plans being submitted to the board in September?
Yes, ma'am. So every meeting you have with any board or typically result in some kind of homework. You get, for instance, you'd like to see a ecology study of the property to see what wildlife is there, or a noise study, or a line of sight analysis. That homework very often includes changes to the plan sets. In this case, I believe we had updated landscaping around the property, as well as and done some de minimis work regarding the stormwater installations proposed. A lot of those will come from a town engineer, by example, as they review your initial application for completeness, that they will note where you may need to change or have questions for your engineering group.
So the plans marked as Exhibit 4 were submitted by ASD in response to a request from the town?
That is correct.
Okay, Mr. Turner, if you could turn to Exhibit 5, please, in your exhibit binder. What is Exhibit 5, Mr. Turner?
Large-scale plans and other accompanying information for ASD Three Rivers Solar LLC to the planning board submitted by TRC October 9th, 2018.
And the second page of exhibit, we're on 5. The second page of exhibit 5, Mr. Turner, includes also a letter from TRC. Is that right?
Yes, ma'am.
And does that letter identify certain additional materials that are being submitted by ASD Three Rivers in support of its application?
It does. I see a landscaping plan, the noise study, and more de minimis work on the stormwater basin included in this list.
And was exhibit 5 again submitted in response to a request from the planning board?
It was.
Can you explain what the information contained in exhibit 5 was meant to convey generally?
Yes, ma'am. So during the course of the public hearing, abutters and planning board members, as well as the applicant, can express desires to see changes to the project's design. In this case, the applicant was willing to go above and beyond all of the stated bylaw requirements to address the concerns of the abutters, and which often come as questions or requests from the planning board. In this case, the planning board wanted, because an abutter naturally has a question, do these make noise? The answer is no, but they say the inverter in the center of the array makes some noise. Well, let's do a noise study just to make sure. So we will engage TRC and their certified engineers to do a noise study, which is then submitted and to the planning board in time for the next meeting. In addition, that may be landscaping. We feel like there's a place where we can increase setbacks, decreasing the size of the array, and improve the visual screening to address concerns, well past the point of the bylaws requirements, in which case we need to revise the site plan to do so, which is what we had done in between the first and second meeting. I believe this is from second to the third meeting is what this submission was done for. That also, I think in this case included, due to some abutter requests or questions filtered through the board, the inclusion of a residential style alternating wooden picket fence to address the concept that in the winter before the landscaping grew in, that there might be the ability to see the array less screened, even through the 100+ feet of buffer and vegetative plantings around the outside. So we offered to put in a large wooden fence of a residential nature, much like a suburb, at a height that the abutters requested to be super tall, above the height of the array, because it would make them more comfortable. So those things all have to get engineered into the plans.
Appreciating, of course, that this happened nearly 2 years ago, Mr. Turner, I think we are a little ahead of ourselves. The date of these plans marked as Exhibit 5 appear to be at the beginning of October. Is it correct to say that these Exhibit 5 was submitted just prior to the first public hearing?
Yes, ma'am. I believe so. I am getting ahead of myself. Thank you.
That's okay. You're keeping a lot of information in that head. So now that we're on the subject of the public hearings, Mr. Turner, can you tell me how many public hearings did the planning board hold on this application?
3, ma'am.
And do you remember what the date of the first public hearing was?
I believe October 10th of 2018.
And who for ASD? Who attended that first public hearing for ASD Three Rivers?
Yes, ma'am. Luke Rickard, Mr. Lawrence Cook, myself, and Mr. Jeff Brandt from TRC.
And who spoke at that hearing on behalf of ASD?
All 4 of us.
Did you specifically speak, Mr. Turner?
I did.
And what did you speak to the board about at that first public hearing?
I typically am the driving the conversation, making the application on behalf of the applicant, much like I'm speaking here, describing what we are proposing, roughly where it is, and using subject matter experts such as Mr. Cook and Mr. Brandt, as well as like a subject matter representative, Mr. Lawrence or Luke Rickard, to field specific questions to which they are extremely qualified to answer above my general level of knowledge on the development process.
Did you go through a general overview of the application at that first public hearing?
Yes, ma'am. We go item for item through the application, much like the table of contents.
And would that general overview have included an explanation of the landscaping efforts that ASD Three Rivers was prepared to make?
It did.
Would that, I'm sorry, did that explanation also include an explanation of the size of the facility?
It did.
And did it include also an explanation of the size of the solar array?
It did.
Did it include an explanation of the setbacks that ASD Three Rivers was proposing for the property?
It did.
During that initial hearing, did the board or anyone else mention that a building coverage or lot coverage calculation would be applied to this application?
It was never mentioned by any party.
Did the board or anyone else at that first public hearing mention that a building coverage or lot coverage calculation needed to be done with respect to this application?
No, ma'am.
What happened at the end of that first public hearing, Mr. Turner?
We received some homework as I jumped ahead to before, and they continued the hearing to a site visit the morning of the next normal evening public hearing. I believe it was a 10 a.m. visit and a 6 o'clock public hearing that evening.
And what generally was the homework, Mr. Turner?
So we went back to do the noise study, I believe. No, that had already been done. Landscaping, we improved. I don't remember if at that meeting we did the line of sight analysis. I don't remember which one it was. I would have to refer to the exhibits, as well as some more de minimis engineering questions.
Did the board ask ASD Three Rivers generally to increase the buffering for the site?
Yes, they did.
And did the board ask ASD Three Rivers generally to decrease the array size for the facility?
Yes, they did.
And when the board made the request to ASD to generally decrease the size of the array, did the board mention that it would be required to fall under a certain lot coverage or building coverage analysis?
They did not.
You mentioned that the board at the end of the first public hearing continued the hearing to a site view and a public hearing to be held on October 24th.
Correct.
And did the board request that the additional materials they wanted to see from ASD Three Rivers be submitted prior to that second hearing?
Yes, ma'am. It is customary to do so. Otherwise, you don't have anything new to speak about for the homework you've done.
In that vein, Mr. Turner, could you please turn to Exhibit 6 in your exhibit binder so that you and I will have something new to discuss? Okay, and what is Exhibit 6, Mr. Turner?
TRC submission providing a wildlife habitat estimate for on 23 October 2018.
And is Exhibit 6 some of the additional materials that ASD Three Rivers submitted prior to the second public hearing?
Yes, ma'am.
Can you explain what the wildlife analysis and habitat evaluation is?
Yes,
generally?
ma'am. Yeah, so it typically comes as a generic question from a board, what's out there? In this case, do you have generic semi-suburban woodland? Do you have any particular species or of plant or animal that are worth noting? Of course, the abutters will mention they see X, Y, and Z on the site. So you go get trained ecologists and wetland scientists to look at the site, take an inventory of what's there, and determine if there's anything exceptional on the property, being the typical goal of the wildlife habitat. That takes place typically over 2 or 3 weeks so that the people observing and assessing can take multiple trips at multiple times of the day in order to get a more comprehensive view instead of just one Tuesday at 9 a.m.
And did the habitat analysis in this case, Mr. Turner, reveal any specific species of flora or fauna that needed to be protected?
It did not. Typical suburban woodland for Massachusetts.
Could you please turn to Exhibit 7 in your exhibit binder, Mr. Turner? And what is Exhibit 7?
A permitting site plan for ASD Three Rivers dated October 24th, 2018.
Is Exhibit 7 some of the additional materials that the board requested ASD Three Rivers submit in advance of the second public hearing?
Yes, ma'am.
And what do these revised plans marked as exhibits show?
The primary difference was an increase in the setback from the property lines from 50 to looks like about 85 and 70 or 100 feet, as well as increased landscaping around the site, and resulting from, of course, all of that increased setback and landscaping, the array naturally shrinks a significant amount. So
these plans show first, an increase in the setbacks that ASD is agreeing to put on the site?
Yes, ma'am.
Do they also show that ASD is agreeing to reduce the size of the solar array?
They do.
And do they also show that ASD Three Rivers is agreeing to increase the visual buffer and landscaping on the site?
They do, ma'am.
You mentioned, Mr. Turner, that the board conducted a site visit of the property, correct?
Yes, ma'am.
And that site visit, I believe you testified, was on October 24th, 2018?
It was
And that would have been just before the second public hearing.
that morning. Yes, ma'am.
Who attended the site visit on behalf of ASD Three Rivers?
Myself, Mr. Lawrence Cook, as well as, I don't recall if Jeff Brandt was there. I do not, and Luke Rickard was there as well.
And what generally was done at this site visit, Mr. Turner?
So the site was showed to the planning board as well as members of the public who came. We started at the street entrance where the driveway would be, walked down through the neck of the property, and then walked around the site. In large part, it follows the existing woods footpaths that are there. In some cases, as a group, we deviated from those paths in order to look at perspectives from abutting property lines to setback areas that were then proposed and later increased, as well as getting an idea of like looking at the wildlife habitat that was described in what we provided earlier in this previous submission. We took that on a clockwise trip around the site, just generally taking stock of the areas and what the visual setbacks look like.
And in looking at the visual setbacks, Mr. Turner, did you point out during the site visit where any portion of the development would be?
Yes, ma'am. So I had roughly mocked up, put tarps up just so they were large, colorful items that people could see at an approximate, height and size is not the right word, but just an approximate height of a colorful item so that people could go to a property line that they might have a question about and look back into the property and see approximately where something would be without having to have someone stand there and wave their arms and guesstimate.
And you testified that the second hearing took place this same day and later in the evening?
Correct.
Who from ASD or who attended this second public hearing on behalf of ASD?
Myself, Mr. Lawrence Cook, Mr. Luke Rickard, and Mr. Jeff Brandt.
And did you speak at this public hearing, Mr. Turner?
I did.
And what generally did you speak about?
So we covered the site walk that we had done, and we typically start that meeting, or we did start that meeting by covering the differences in the plan set that from our previous submission. So we talked about the increased setback, we talked about the increased amount of visual screening, how we shrunk the array, as well as we added some landscaping around the entrance on this plan set as well. Those are, and then there's the normal host of abutter concerns, abutter questions, sight lines that naturally come up with the project.
And in talking about those changes, Mr. Turner, did you present the plans marked as Exhibit 7 to the board?
I did.
And did you go through them to explain the increased setbacks?
I did.
And did you go through them to explain the reduction in the solar array?
I did.
And did you go through them to discuss the landscaping enhancements?
Yes, ma'am. That is a large point of emphasis on most of these meetings.
Why is that, Mr. Turner?
Abutters are naturally concerned about the potential visual impact of the array. So especially when we're going above and beyond and we're putting all of this extensive landscaping in, it's a lot to describe. That also, the planning board had similar questions of why did you change the plan set? And in this case, we did it to reflect their concerns and to just be, I guess, an above and beyond kind of design.
And when you say above and beyond, Mr. Turner, do you mean above and beyond the requirements in the bylaw?
Yes, ma'am. Section 10.7 requires a 50-foot setback. And I believe the wording was screened visually to the maximum extent practical. So we want to go right past that and go to the absolute maximum extent functional, which is what we've done with these submissions.
Okay, Mr. Turner, you testified a couple of minutes ago that one of the things that was presented to the board as part of Exhibit 7 was the fact that the solar array had been reduced in size.
Yes.
During that discussion, did the board mention that there would be any specific building coverage or lot coverage calculation that they would consider with respect to this application?
They did not.
Did the board or anyone else mention that there was a specific size or percentage of the lot that ASD Three Rivers would be required to comply with?
They did not. When we asked what size they had in mind, because they repeated the desire to see it smaller, they said just smaller was the only guidance given.
Okay, Mr. Turner, I'll ask you to turn to Exhibit 8 in your exhibit binder. Could you tell us what Exhibit 8 is, please, Mr. Turner?
Yes, ma'am. Dated November 5th, a filing by ASD Three Rivers MA Solar LLC for a revised set of plans and modifications that include a number of bullet point items.
What are those bullet point items, Mr. Turner?
Yes, ma'am. Pulling back of the array from the property lines and making the array smaller. There are now setbacks of 150 feet to the south, 100 feet from the east and north, and a very large setback from the street. A 9 to 10 foot high wooden fence and 2 foot high berms to block views from neighboring areas with adjustments to the landscaping, edits to the plans, including a culvert change for the large retaining basin and minor changes for the alignment in the southwest corner.
Did the plans and submissions marked as Exhibit 8, Mr. Turner, show a further increase in the setbacks of this site?
Yes, ma'am. They went from the the above 50 feet in the second edition to 150 feet at the south, 3 times the bylaw requirements, and 100 feet on the north and east sides, where it was still a 50-foot setback requirement. And they were all wooded setbacks in that 50 feet, of course.
I'm sorry, Mr. Turner, what do you mean when you say they were wooded setbacks?
Yes, ma'am. So the bylaw doesn't specify what the setback has to be. It's a setback from a property line like any other building, but we considered it appropriate that the setback itself remain wooded with its existing vegetation, as well as the interim setback after that initial 50 feet of untouched. Think of it as untouched foot setback. The next in 50 or 100 feet to meet our 100 or 150 foot total setback had vegetative, screening, landscaping to get specifically what we wanted there that has the best visual screening characteristics over a project's lifetime, as well as it was selective cutting. So we're leaving most of the trees, but only taking the ones that have some shading impact. So effectively it becomes 100 to 150 feet of wooded buffer, some which we leave, some which we enhance considerably with the landscaping.
And can you explain why ASD Three Rivers included the addition of a high wood fence and berm with the submission marked as Exhibit 8?
Yes, ma'am. Ultimately, it comes down to because we could and we wanted to be good neighbors. Some of the abutters, and through them the board accordingly, expressed the chance or possibility that in the winter, when there are less leaves on the trees, and before the landscaping grew in, that it might be possible to see the array through that distance. Landscaping growing in at height, so that an arborvitae that starts out at 5 feet won't get to 8, 9, 12 feet for 2 or 3 years. And so we installed a berm to raise the height of the landscaping and the fence, the baseline, proposed to install, my apologies. And then we put a very tall fence in at the request of the abutters who made it that tall, so that at a 12 feet height or foot height, it would be taller than the solar array to begin with, of course, in all seasons and all weather. And of course, being in a residential zone, we make it residential in nature because that's what is appropriate for an item that size there. So it's an alternating wood picket fence. The standard wood posts into wood slats that are vertical, with a couple breaks in it to let wildlife through, but overlapping such that you can't see right through.
Was this fence that you've described, Mr. Turner, required by the bylaw?
No, no, ma'am.
Did you also, I'm sorry, Mr. Turner, you testified also that Exhibit 8 included further adjustments to the landscaping that ASD Three Rivers was proposing for the site. Is that correct?
Yes, ma'am, it is correct.
And we've talked a little bit about the landscaping and the adjustments that ASD Three Rivers made over time. At this point, can you describe, by the time we got to Exhibit 8, the type of landscaping, I know you've gone into a little bit, but the type of landscaping that ASD Three Rivers was agreeing to put in as part of this application?
Yes, ma'am. So looking at page L100, it is a mix. TRC worked with a landscape architect, TRC, for the most enduring, best screening mix of trees and shrubs. The vast majority are evergreens. Many of them are fast growing tree species that hold up well over time. And others are heavy growing lower bush species. And the exact locations, very specifically planted to provide a mix that also does well with, over the years doesn't get a single species that get knocked out to an infestation, or ones that have the exact same tolerance to heat and cold or drought or rainy seasons, such that we have a very reliable mix of both height and type of species to execute the screening in all weather and all seasons. And those surround the entirety of the array.
What is the purpose of this extensive landscaping, Mr. Turner?
Courtesy to the neighbors. Neighbors naturally hear about a solar array and they want to make sure that their lives aren't going to change. So part of the public hearing process effectively is to take every step that ensures their lives won't change. And in this case, we wanted to go above and beyond the 50-foot setback. And so we installed the landscaping, we installed the fencing to make it suburban in nature. What we were effectively going for was a very, well done suburbia, street frontage, for instance, that you'll see, on nice suburban neighborhoods where they install berms and plantings and normal privacy fences. We did the same thing, which is not typical of a solar array, but the neighbors expressed they'd like to see it. And our goal is we're going to be there for 20 to 40 years upon successful execution of a permanent construction. So we're trying to be good neighbors for the long term. Way better to overdo it.
So was this landscaping designed to shield the array from abutting properties?
It was.
And it was designed to shield the development from abutting properties?
It's designed to shield everything from abutting properties.
And was it also, in addition to providing a visual buffer, was it designed to make sure that your site upon completion would be consistent with the surrounding neighborhood?
It was. That was its explicit purpose.
Mr. Turner, these landscaping additions that you've described, which you've described as being above and beyond the bylaw requirements, did they add to the cost of this project for ASD Three Rivers?
Significantly.
When you say significantly, Mr. Turner, can you give us an approximate amount of money? I
recall doing the calculations then between the landscaping and the fence. I would have been happy to add $300,000 to the total project budget to build these, much less the maintenance of the landscaping over time, which is not insignificant. Since it's on a plan, it has to exist. If it dies, you go back and replant it. So $300,000 is a starting spot.
So ASD Three Rivers made a significant investment in this site, Mr. Turner.
Yes, ma'am.
And part of that significant investment was designed to ensure that this site would appear to be consistent with the surrounding properties.
It was.
As part of the submission marked as Exhibit 8, Mr. Turner, did ASD Three Rivers present a sightline analysis?
They did. One was requested by the planning board at the previous meeting.
Is that why the sightline analysis was conducted, Mr. Turner?
I think it was why it was provided to the board. We had conducted them ourselves just out of normal site diligence and did not see any problems with any of the sight lines, but the board specifically to one abutter did ask for a sight line analysis. We offered them for many spots, and I believe they just wanted that one.
And what generally does the sightline analysis show, Mr. Turner?
It shows the line of sight from one location to a next, and then presumably, if you know what's at that second location, what the person at the original will see.
And what does this sightline analysis show?
Yes, ma'am. So the way it was constructed was that we went to the second story of the abutter directly opposite the entrance, whose name I remember to be Victor, who raised the specific concern. And we took the line of sight from his second story over the trees that exist adjacent to our property and on our property that would remain permanently under the special permit. They're also wetlands, so they are exceptionally durable from a development standpoint, being state, federally, and locally protected. And we take the line of sight from point A to point B. It gives you a slope, so then you can follow that slope until, or if you hit the terrain on the other side, in this case, barely being able to see to the bottom right, which is the southeast corner of the array area, just inside the limit of clearing there, which is also the relative highest point on the property.
And I believe Mr. Cook testified that that was probably between less than 10% of the total solar array.
Certainly.
And this is the portion of the solar array, Mr. Turner, that would be visible from the second floor of this abutter's property and visible right now. Is that correct?
Probably. Well, so right now being this present year, yes, ma'am, we took the height of the trees, which of course will get taller. So I don't see that sightline getting, I guess, worse. It'll get better for the abutter as the trees continue to grow in. And yes, it is from, they have a single window facing the street, which is therefore facing the solar array of their second story. And I believe we went to something like an 18 or 20 foot eye line height to represent a tall second story and a relatively tall person standing there. Because of course, the higher you take that vantage point from, the more of the array you can possibly see. So we took every possible liberty on how high you'd be looking at it to determine the potential sight line.
And you say,
Can I ask a question here? And perhaps if there's going to be more testimony about this conclusion of 10%, I would appreciate that, because I guess I'm not really sure what 10% means. I don't understand that. Maybe Mr. Turner can help out. Is that 10% of the entire array you'd see, or is it height, or I don't know what it means?
Yes, ma'am. So it is roughly, we're talking about what, if you looked at the array from a top-down perspective, it would have a square footage or something to it. So what percentage of that square footage could be visible from that location over the trees? Most of it, the vast majority of it, even presently, would be hidden behind the trees that are part of our wooded setback, and then the natural surrounding forest as well from that perspective. The array doesn't start for at least 500 feet off the street from that abutter's direction.
and perhaps Mr. Turner, to explain it more colloquially, would it be fair to say that the portion of the development that would be visible under this sightline analysis would be a very small corner of the development?
Would be. I'm not even convinced it's 5 or 10% by area. It's more or less, you can see a little bit of the modules over the trees upwards of 1,300 or 1,500 feet away.
And as you mentioned, Mr. Turner, that sightline analysis is based on the height of the trees as they exist when the sightline analysis was conducted.
Yes, ma'am.
So over time, will that view change?
It should get less of a view as the trees continue to grow. Because the higher you put that object in between the viewer and the viewed, the more obscured it is.
And was this information with respect to the sightline analysis contained in Exhibit 8 presented to the board at the third public hearing?
Yes, ma'am.
And when was the third public hearing, Mr. Turner?
I believe early November, I think November 14th, second week. I'm gonna go with November 14th, man.
I can confirm that you're correct, Mr. Turner.
All right.
And in addition to presenting the sightline analysis at the November 14th meeting, did you also present the further increase to the setbacks and the further reduction to the size of the solar array?
We did.
And during your presentation or after your presentation about the further reduction to the size of the solar array, did the board or anybody else mention that a lot coverage or building coverage calculation would be conducted on this application?
They did not.
Did the board or anybody else mention during this third public hearing that the building coverage provisions of section 4.4.4 of the bylaw would apply to your application?
They did not.
Had Three Rivers performed those building coverage calculations on its own by the close of this third public hearing?
No, we hadn't. It wasn't part of the applicable solar bylaw.
And what happened at the end of this third public hearing, Mr. Turner?
The planning board closed the public hearing. Everyone filed out of the room and we went on our way. My understanding is later that night, the board did vote on the project or the application.
And when was the first time that you found out that the building coverage provisions of section 4.4.4 were going to be considered and applied by the board with respect to this application?
That would be when I read the written decision for the first time in their January public hearing where they voted on the formal written decision.
And when is the first time that you found out that the board believed and would rely on its belief that this project would reduce home values in the surrounding neighborhood?
At that same time in the written decision.
Were property values raised prior to the issuance of the written decision?
They were raised by an abutter, and then I believe, yeah, by an abutter, or I think it was an abutter, I'm sorry, it was several years ago. As a concern, they are a typical concern of abutters and are over dozens of projects and more dozens of meetings, never been, I mean, I've never seen them verified at all, but always a natural concern of an abutter.
So you often see general concerns about property values from abutters at hearings with respect to solar facilities?
Yes, ma'am, they're always raised and they're never ever substantiated.
Did ASD Three Rivers present any specific information to the board with respect to loss in property value?
No, ma'am.
I'm going to ask you to turn back to Exhibit 3 in your exhibit binder, Mr. Turner. On page 4 of Exhibit 3, Mr. Turner, there is a paragraph. I'm sorry, Mr. Turner, we're looking at Exhibit 3, which is the decision.
I was on Exhibit 2, that'll do it.
I could tell because Exhibit 3 is so much skinnier.
Page 4.
There's a paragraph marked as number 16. Do you see that paragraph?
I do.
And do you see, Mr. Turner, that there is a comment attributed to a representative of ASD with respect to property values in that paragraph?
Yes, the last sentence, which I took great issue with at the January public hearing.
If it's okay with the court, Your Honor, because I'm talking about a specific sentence, I will read this sentence.
Okay.
The sentence that
Any objection from Attorney Marshall?
No objection.
the sentence that I'm referring to, Mr. Turner, reads, while the applicant's representative was aware of any published data to either support or refute these claims, he did provide anecdotal evidence in support of the claims by stating that some communities have used pilot money generated from commercial solar projects as a form of monetary compensation to abutting property owners. Do you see that?
I do.
And who is the applicant's representative referred to in that comment?
That is myself.
And is that an accurate recitation of comments you made at the public hearing?
No, ma'am. It is both inaccurate and taken out of context.
Can you explain what you mean, Mr. Turner?
Yes, ma'am. So I did not support the claim that this reduces property values. I was asked by an abutter, I believe, if it thought it increased property values, to which I said, no, I don't think it has any effect on property values. But I did, again, I'm at these meetings talking for several hours at a time with often people who are understandably concerned and occasionally not the most even-tempered, that I often wondered if towns and residents had these unsubstantiated concerns that repeatedly come up. Why, if there was such a real concern, did they not consider addressing it themselves, obviously through some revenue that the array could make? More me thinking out loud, certainly not me making a statement that towns had done it. It was, I guess, so that is both inaccurate and out of context. It sounds to me, when I read this, I asked the chair of the board how they got there and told him this is not what I said, out of context. And his answer to me on that was, I can understand that. And then they proceeded forward to vote and close, or sorry, vote and sign.
Do you agree with the determination that property values would be reduced as a result of this project?
No, ma'am, I do not.
And is that largely as a result of the fact that this project will not be visible, in your opinion?
In many cases, yes, and that's a large factor, but also I'm not qualified to assess property values.
Are you an appraiser, Mr. Turner?
I am not.
Are you qualified to give an opinion with respect to real estate value?
Not that I'm aware of.
Okay, Mr. Turner, I want to finally address some of the additional requirements that ASD Three Rivers was required to do with respect to this project. But before I do, I want to go back just to that sightline analysis we discussed briefly, well, not so briefly in Exhibit 8. This is the only sightline analysis that ASD Three Rivers filed with the board for this application.
Correct.
Would you have provided additional sightline analyses?
Yes, ma'am. So when this topic came up, similar to how we come back and address all the homework the board asked for, we asked if they wanted sight lines from any other property or residents abutting the site. And they said no, this was the only one they were requesting. So this is the only one we provided. They never raised the sight line from any other property, just this one across the street.
Thank you, Mr. Turner. You mentioned much earlier in your testimony that there are certain other things that ASD Three Rivers was required to do here, including, for example, an interconnection agreement. In addition to obtaining a special permit for this site, can you describe generally, again, what other items ASD has to consider or procure for this facility to be constructed, operated, and maintained?
Yes, ma'am. So it starts with effectively three things that build into one thing. The one thing you were trying to arrive at is an allocation and qualification for the state solar program. In order to get that, you need to demonstrate control of the property, in this case, a purchase option. You need to demonstrate that you have the permissions to connect to the grid for the proposed system, in this case, to the wooden telephone poles that run along the street at Three Rivers Road. And you need to demonstrate all permits have been achieved necessary to construct the project. With those three things, you go get that one thing.
And what is a purchase option agreement, Mr. Turner?
In an agreement with the present owner of the property to, at the buyer or the purchaser's discretion, purchase the property for a fixed price with rights that extend for a fixed period of time.
And was such a purchase option agreement obtained for this site?
It was. That is the initial thing you do to have a site at all.
And was that purchase option agreement renewed as necessary with the current property owner?
It was. I can remember being renewed at least twice.
And is it currently valid and still in effect?
It is.
And can you explain what an interconnection agreement is, generally?
Yes, ma'am. So you talk with the local electrical utility, which is in this case National Grid, and you apply to connect the solar array to the local electrical network. That, of course, requires some study by the utility to make sure that the power delivered is appropriate and safe for that electrical network. They give you effectively, and it's called an interconnection service agreement, which is an agreement to interconnect the site to the local electrical network. and perform, of course, the service of it over the decades.
And was an interconnection service agreement obtained here, Mr. Turner?
It was.
And was that interconnection agreement renewed as necessary with National Grid?
It has been, yes, ma'am.
And is that interconnection service agreement currently valid and in effect?
It is.
Excuse me.
Yeah.
Would it be possible if we just broke here for just maybe 5 minutes?
Just want to take a break for 5 minutes. Does anybody have any objection to that?
No, actually, I have nothing further at this moment for Mr. Turner.
Okay.
Okay, all right, so,
Have a little more than 5 minutes then? I thought I was.
So- so then you'll be ready for cross when you come back.
Yes, ma'am.
Attorney Marshall, yep. Oh, I think,
So
it's-
maybe 5 after that, I'll start cross.
why don't we come back at 2 o'clock, okay? Does that work? Or you want 5 after 2? What do you want?
Make by 2.
By 2? Okay, we'll be back at 2. Everybody mute yourselves and turn off your video, okay?
Thank you, Your Honor.
Thank you.
Thank you.